Welcome to
Good
today's
afternoon.
program titled Coronavirus and Remote Workforce, Best Practices for Protecting Trade Secrets and Intellectual Capital. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write the code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and PowerPoint presentation will be distributed to attendees in the days following the webinar. At this time, I would like now to turn things over to Michael Wexler. Michael, you may begin.
Great, thank you. Good afternoon or good morning, depending on where you are in the country. And we hope everyone is staying safe and staying healthy, and that we're glad that you could join us to hopefully provide some information that is certainly relevant today with regard to protecting your trade secrets, your intellectual capital, with what has become a massive remote workforce. Your presenters today are myself, Jesse Coleman, and Justin Beyer. Just so you understand, if you want to get additional information regarding COVID-19, Seyfarth has set up extremely helpful and informative website that you can go to. That's on the screen, seyfarth.com/COVID-19. That has all kinds of information in most relevant areas of law and new changes in government orders and state orders. So it's a very useful website today. Just so it's clear that this presentation is prepared by Seyfarth, and the matters discussed in this webinar are not to be considered as legal advice or legal opinion for any specific facts or circumstances, and the contents intended for general information purposes only. And of course, you're urged to consult your personal attorney concerning your own situation and any specific legal questions you have. But that's not to say we will answer questions at the end. And feel free to put questions into the typed box, which should be at the bottom right of your screen. What we will cover today, our objectives are to hopefully answer the following questions: whether you need challenges of coronavirus, what needs protection, why does this matter, what do you have in place currently, and what should you be doing now? As I mentioned, there's a good-looking bunch of folks presenting here today. And without further ado, you can look in certainly the printed materials, and you'll be able to see the biographies of each of us as well as contact information. And with that, I'd like to turn things over to Jesse Coleman.
Thank you, Michael. Good afternoon, good morning, happy Friday to everyone. My module and what I intend to talk today about are the unique challenges that the coronavirus presents to trade secrets and confidential information, and kind of set up the stage for some of the things that what certain steps can be taken by you and your organizations in order to institute reasonable measures to maintain the necessary secrecy for your intellectual property. So I'm going to give a quick primer on trade secrets. I anticipate that most of you are familiar with the general definitions of trade secrets, and so I won't spend too much time on this, but I do want to introduce some concepts that are going to be revisited by my colleagues, and specifically concepts that are related to trade secrets and how to maintain their secrecy. And so as I bring these up, I want you to think about how these are impacted, and we'll discuss this in the unique situation of the coronavirus. So trade secrets are among the most unique and elusive areas of law. There are specific challenges that are raised by the coronavirus environment, where there's two major regimes for trade secret law. There are state statutes that are based on the Uniform Trade Secrets Act. Here's the definition for that. And then, of course, there is the Defend Trade Secrets Act. I won't spend a lot of time on the definition here. I anticipate that most of you are familiar with it. Trade secret is a very broad concept in terms of what can fall under it. You have formulas, patterns, compilations, programs, devices, methods, techniques. I could go on the DTSA has similar definitions, but the key aspects for these, and I've highlighted them here with regards to DTSA and UTSA, is that it is some form of information that is kept secret and that are kept secret through reasonable measures. It gains independent economic value from being kept secret. And so basically you have here the elements. It's not known to others. It's economically valuable. It's that the economic value comes from being kept secret. You have another area of law, intellectual property law and patent law, which protects economically valuable information that is not kept secret, that you can find out about, and the reasoning for patent law is to protect that information getting out into the public, but then you have a patent to protect those ideas. And that there are reasonable efforts to maintain their secrecy. And I think that is the key issue that I think we're going to be talking a lot about today. Many of you may already be familiar with trade secret statutory regimes and what the standards are for maintaining secrecy, and this is all greatly impacted by the coronavirus environment. Obviously, trade secrets must be kept secret. Public disclosure of trade secrets destroys their status as a secret. Without that secrecy, it is no longer a trade secret. 15% of trade secret cases in the 10 years leading up to 2019 were dismissed because the plaintiff did not take reasonable measures. And that's something very important to understand as we're looking at a workforce that for at least the immediate foreseeable future is going to be remote, and many of whom are going to be in environments they've never worked in before, but may have access to confidential, proprietary, and trade secret information that they need to use reasonable measures to. So what's the level of security required? Again, this is a reasonableness standard. Reasonable under the circumstances. Your organizations want to have prevention protocols that are in place. Value may be lost or severely compromised if it's leaked, and courts will obviously carefully scrutinize whether appropriate steps are taken to safeguard security. These are all general concepts that you may be familiar with. What needs protection? Well, looking first to the factors that determine whether it's maintained as a secret. We look to how much it's known outside of the company, how it's protected inside the company, what group or class of employees may know about the information, the measures to protect the information, how it's kept secret, the value of the trade secret to the company, what value comes from actually it being maintained secretly or confidentially, the time, money, and effort that's expended into the development of it. This obviously can result in the various types of damages that are available for trade secret misappropriation. You have head start damages, information given to another company, for example, that will allow them to get a head start in the industry, and the ease with which it can be properly acquired or reverse engineered within the industry. These are all factors in determining whether it's a trade secret. A couple examples of trade secrets that you may have within your organization. Internal customer lists. These come up very frequently in the case law. Internal modeling documents, SWOT analyses, internal opportunities and trends, strategy documents. This can include information, for example, as well, that's compiled from public sources, but for which there was a considerable effort by the organization to gather the information together and put it in a format that is particularly useful to the organization. So all of this may be considered trade secrets. There's a further list. Product formulas, obviously, the sauce, so to speak, the WD-40 or the Coke formula, so to speak. The manufacturing processes, the strategies on how to bring the products to market, business plans, obviously financial information, cost information, source code, knowledge about customers, customer preferences, what what a particular organization knows about its customer base that is not particularly known to the industry or to its competitors, what they prefer, what they don't prefer, who the contact people are if this information is not generally known. Negative research results. So I mentioned WD-40. This is a great example of negative know-how. You've got WD-40, and that means there has been 39 efforts to get to the perfect blend, and those are 39 failures, so to speak. 39 examples of lots of energy and effort that are put into trying to come up with a result. If a company is able to go right to WD-40, they have been able to avoid the millions of dollars of energy and effort that has gone into developing that trade secret. So all of these things are examples of trade secrets. It's important to understand that up to 3% of the gross domestic product of the United States and other advanced industrial economies that is the economic impact of trade secret theft. So this is, while it's a very difficult concept to define and an incredibly difficult cause of action to prove, it has a very real impact on the United States. There are really two different ways that trade secrets can be misappropriated. One is simple negligence or recklessness on behalf of employees, executives within a company. They can allow information to get leaked into the public, and then the information becomes known. On the other hand, there are direct efforts, there are intentional efforts, and those take many forms. There's conspiracies, there's there's conversion in certain jurisdictions, but then of course there's cyber threats, and information can get posted on the internet. There can be computer fraud. Cause of action that often goes with a misappropriation of trade secrets is a Fraud and Abuse Act claim, where a person accesses a company's computer systems or without authorization, or exceeds the authorization that that individual has in order to misappropriate trade secrets or otherwise transfer them. So this is a very real threat. This is often the form in which trade secrets are taken. This can involve transferring data to the cloud. This can involve downloading information to external storage devices. Believe it or not, the quintessential cliched trade secret case, employee who at the very last minute decides to plug in a flash drive to his or her laptop and download the contents of that laptop and walk out the door, is still very much a live fact pattern that occurs throughout the United States. And these are forms of cyber threats. Also hacking, obviously, from individuals and from government actors are threats to a company's information. So what can be done to protect trade secrets? And again, I would challenge you, as we're thinking, as I go through these, and I'll go through them very briefly, to think about how these are being impacted and how the coronavirus, the current health crisis, is calling into question whether or not your organization has these measures in place. And Michael and Justin will talk more about how you can augment those measures so that they are considered reasonable under the circumstance. So we have agreements with the employees, obviously, non-disclosure agreements, requirements to return materials, post-employment restrictive covenants. I'm sure many of you are very familiar with these. Policies and handbooks, confidentiality, codes of conduct are very important. Agreements with third parties, anytime information is shared of a confidential nature, whether or not practices are in place or signed agreements are in place with those third parties. Courts will look at all of these. Whether or not your network is secure, whether you have passwords, encryptions, whether information is under lock and key, so to speak, and other monitoring tools that we'll talk more about as we go on here. The limit of access and the actions that are taken on the back end are also looked at in determining whether or not reasonable measures in any trade secret misappropriation has occurred, and whether or not action, including but not always filing suit, also isolating and quarantining areas where information has been in custody, whether or not sufficient training has taken place, onboarding and exit interviews. Again, all of these are elements that a court will look at and that you should keep in mind for your organization in any trade secret case when determining whether or not you are taking or your company is taking reasonable measures under the circumstances in order to protect what you consider to be. So why are we talking about all of this today? This sounds like general trade secret 101, so to speak. And we do webinars on these issues all the time, and there's a lot of great literature out there about it. We have a blog that addresses these. Well, the coronavirus healthcare crisis is creating new challenges for companies addressing these issues, in particular in the area of work at home. The reason why is because huge sections of our economy are now being forced to work in environments where they've never worked before, primarily at home. As of 7:30 a.m. Central today, there's over 500,000 cases of the coronavirus. There are almost 25,000 deaths and nearly 130,000 recoveries. The United States has now surpassed China as the country with the greatest number of cases. Thank goodness we don't have the greatest number of deaths, but as we'll see, we're still working up the wave according to all sources. A third of the global population is currently on coronavirus lockdown. 46 states have issued stay-at-home orders or placed limits on gathering. Most of these are stay-at-home lockdown. Some states, such as the great state of Texas, have left it to the individual counties. Most of those counties have also issued lockdowns. Those where they don't have lockdowns have orders that require less than 10 people to gather. There are, of course, exceptions for essential businesses and organizations. HHS, the Center for Disease Control, has recommended staying at home and engaging in a term we're all getting very familiar with, the social distancing. And most importantly for what we're talking about today, major information companies, and perhaps your company, have instructed all non-essential people to work from home. On a related matter, interestingly, the HHS has waived certain penalties to allow for the exchange of information that would otherwise be considered protected health information. They've waived penalties for covered hospitals and disaster zones. These are specific areas that are being hit by the coronavirus, but are nonetheless otherwise subject to what are considered breaches under the HIPAA privacy rule, and the HHS has waived penalties to allow for the free flow of information in those areas. But obviously your company still wants to protect its information, and we're doing that in an environment where the U.S. Surgeon General has come out and said, and he said that this week, this particular week, it's bad. He said it back at the beginning, we really need everyone to stay at home. So on one hand, you have these recommendations and requirements from the government. On the other hand, you have companies that say, look, we can't close. It will kill us. So we have folks working from home. And this creates heightened risks to trade secret misappropriation. Some of the immediate impacts is that you have remote working environments where none existed before. You have the use of unsecure personal and public Wi-Fi networks. You have the use of unsecure personal devices. This is true even in situations where companies have robust trade secret training. Under normal circumstances, you now have additional groups of employees who are working that may not get that training, that may not have the NDAs, but necessarily now have to be in these situations. Unsecure use of personal email accounts, transferring corporate data. they can't access their servers or their systems, they're now using their Gmail accounts. We're seeing syncing with unsecure personal cloud storage accounts. We're seeing heightened use of Dropboxes, Google Drives, other systems that may not have the same level of security when used publicly that you would in your company. We have employees that are printing out reams of materials that they can use at home where otherwise they would be in secure environments. We have the use of unencrypted portable electronic storage devices, i.e. flash drives, and of course connections to the employer systems through unsecured VPNs. There are unsecured conference call lines that are being used, Zoom and others, which may have heightened security measures if used through the company's accounts, are being used through private accounts, and information is. As we move into a home-only environment, we're seeing less of the next one, but there are at least still concerns that individuals who are not used to working from remote locations are now working in public locations, and information is being shared inadvertently there. And going from the inadvertent to the deliberate, we are seeing increased phishing schemes, fraud, attempts to hack into these environments where the security systems of companies which may ordinarily otherwise be safe are now subject to strains that they're not used to. So the risk for fraud and hacking has increased. So what to do about these unsecure environments, what to do in order to reduce these risks. I'm going to turn it over here to Justin Beyer to talk a bit more about these and related topics. Justin?
Thanks, Jesse. So I want to start off by reminding everyone of something that Jesse mentioned a moment ago, which is this question of what you need to do. And the reality is that nobody requires Herculean efforts to protect trade secrets. What has to be done is reasonable efforts. And so as we talk a bit about the policies and procedures that companies have in place to protect those measures, I want you to keep in front of mind the question of reasonableness. Whether or not information is being restricted to those who need to have access. Do employees have access to information? Are they signing confidentiality agreements? Are the materials marked as confidential? Are there written company policies? What training is being taken place? Because as we move into this new environment of working from home, trying to social distance, we really do want to continue to stress that there are policy measures, but there's also practices that can be iterated or reiterated to your employees. And one of the ways that we think that is possible is through creating an ACE environment, auditing, creating a culture of confidentiality, and enforcing. And so what does it mean to create a culture of confidentiality? Well, part of it is the aspect of communicating to those in your organization, making sure that they understand that there are now heightened risks available, or there are heightened risks that are taking place because of this work from home environment. Specifically, we need to have things being addressed to employees about teleconferencing, communicating out of office or off network, policies in place for working on non-company devices, addressing employees utilizing unsecure networks, stressing best practices for use, dissemination of confidential information. The reality is just because we are dealing with COVID-19, we can't forget the fact that we have trade secrets that need to be protected and confidentiality measures that need to be dealt with. So how are those done? Well, first and foremost, we would suggest that you look to what you already have. For example, do you have employee agreements in place? Do you have confidentiality agreements, return of material agreements, invention assignment agreements, restrictive covenants? A lot of those tend to be in an overarching employee agreement that most companies or many companies enter into with their employees at the outset of their employment. This might be a good time for HR to pull an example or examples and hold a conference call to discuss what obligations exist and ask employees to think about this. This may be a good time to, have in-house legal look at those and just put together an email that say, remember, you have these obligations. Remember, when you're working from home, that we maintain a clean desk policy at work, and you should be maintaining a clean desk policy at home. If you're, working in an office that has, let's say, a smart speaker in it, maybe you need to move that to another room for now. Just things that are reminders to utilize the materials we already have available. For example, another example, do you have a social media policy in place? It may be that we're finding that employees are having more communications with one another via social media, Twitter, Facebook, or even utilizing, communication apps like WhatsApp or House Party or things like that. If you're utilizing unsecure apps to host what would typically be a face-to-face meeting, you just want to think about that. Think about how you're addressing confidentiality, warning employees maybe they shouldn't be disclosing, particularly sensitive pieces of information in that platform, or doing it so in a different way via, a phone call one-on-one or an email. Same holds true for your BYOD policies. It's possible that your BYOD policy should be considered at this moment, because in one respect, if it is a strenuous BYOD policy that restricts the ability to use personal computers, that may not be realistic right now. And so you may just need to address it via email by saying, we are going to relax this for now, but we want you to keep in mind the types of overarching concepts that are important through our BYOD. We don't want to expose customer information to this. We don't want to put our own information at risk. And so these are the type of things that you should be thinking about or looking at if you are in HR or in-house, or advising your clients on how to protect information in this particular time. Another thing to consider is, what does your employee handbook say about confidentiality? What does it say about taking company material from the office? If it prohibits it, like much of the information takes place, then it may be something that you need to just address. Again, at this particular time, I don't think we're talking about creating a wholesale or new policy from scratch to deal with work from home environments. But the question again is what is reasonable? And I would posit that a court tested with this question is going to have to consider the extenuating circumstances of this work from home environment. And if you can show via email records or your policies or dealing with any of this that you have restrictions in place, that may be sufficient if you get into a litigation mode later on. But the reality is you shouldn't be waiting until litigation takes place to address this. Not now, not ever. Another thing to keep in mind, what does your information security policy say, or do you have one? Is it going to be consistent with the things that you need to be doing as an organization to address these type of questions? So what do you do if you don't have these policies, or if you do? Well, the reality is, again, that that you want to be communicating with your employees, and I'm assuming you are. You're communicating about the day-to-day aspects of your business. You're communicating about the challenges that a work from home environment is creating. You're communicating about, how long we anticipate this work from home to take place. You're communicating a lot about the overarching business, but sometimes, and particularly in this instance, we need to start thinking about the more granular too. And some of those communication efforts can be very low tech, in the sense of we're sending out an email, or we're hosting a teleconference, or maybe we have an annual confidentiality meeting that we host every June, but now is the time, because everyone is working at home and maybe people are a little bit slower than normal, to host that conference now. The point is you want to be in a position where you can demonstrate that you have been mindful and thinking about the processes and practices of the company. I think it's important. Don't let a work from home environment erode or eliminate your confidentiality efforts. Being able to talk about that at a later date is going to show mindfulness now. A couple other things that you want to keep in mind, and it's possible that a lot of companies have gone into a hiring freeze mode, but the reality is that maybe you haven't, and maybe you're hiring people, and maybe they're not going to be reporting to a brick and mortar office, but they're going to start their new employment in a work from home atmosphere. So it's important to keep in mind that they may have confidentiality obligations themselves to their former employer. It may be that they're going to be working on a device that is their own device, or maybe not part of your overarching network right off the bat. You do want to keep in mind that in this time, you don't want to be accepting trade secrets or confidential information from a competitor, and you want to be making sure to remind these employees of that. The same holds true for the exit interview process. Many companies hold those typically face-to-face. You may not have that opportunity. You may have to be nimble in the way that you are conducting your exit interviews. For example, maybe you can hold it through a video conference or a phone call. Maybe your IT department is going to have a different procedure in place for checking computer activities. Maybe you need to think about what you need to do in order to pick up company materials. Maybe you need to think of, if the company is not operating in a VPN atmosphere, how exactly you're going to reobtain this type of information. So as you go through this, there are a lot of the same steps that you're going to incorporate that you might normally incorporate if everyone is in the office, but it just has to go through a more mindful process now, and really target the fact that this is all being done in a remote atmosphere. Lastly, and God willing, you're not in a position where someone walks out the door and starts competing or using trade secrets right now, but you're going to have to keep in mind that your access to the courts may be limited. Many courts around the country and most federal courts are now restricting civil litigation. They're restricting your ability to get in front of a judge. Even, in a lot of criminal cases, they've been put on hold. So, are there other methods that you need to take into place, take into consideration the types of instances where you actually need to get in front of a court, and can you take some non-litigation type steps in order to protect your information, protect your customer base right now? For example, can you reach some sort of agreement with the other company that they'll sideline them with respect to certain accounts for the time being, or file your motion but indicate the understanding that you may not be getting in front of a judge until several weeks later, just so you almost have a placeholder in place there. And so, with that, we've sort of covered the policy aspect of this, and I want to turn the floor over to Mike Wexler to talk about some of the security procedures that we do have in place. And I will say before I do that, I do note that there's a number of questions that have come in, and for those of you who have issued a question, please wait till the end, and we'll be sure to address any questions that come in after we've had a chance to go through the materials. So without further ado, Mike Wexler.
Great, thank you, Justin. So we've talked a lot about policies and some procedures and protection, but we want to dive a little more into the weeds here because there's a whole group of folks. I mean, most of America is working from home. Folks are sitting at home in different environments and using different devices and using different memory devices and using different ways of communicating with work, using different kinds of computers and computers that are owned by a business or computers that are owned personally. And it presents a whole host of questions and issues that may concern you or concern your business. So we want to try and get a little more granular here and understand some of that. And so one of the things that that I think is incumbent upon in-house counsel to have some, just a little bit of knowledge of or have in the back of their mind is that a lot of issues that are going to arise with a remote workforce relate to forensics and relate to current technology and what can be done and can't be done. And so one thing to understand is that with computer forensics, if there are areas that need to be looked into, there's issues of preservation, which means that if there is a concern about one of your employees and concern about the safety of information, are you taking steps to preserve information if an issue arises? Which means, are you getting a computer, for example, imaged by a forensic professional, which takes a bit-by-bit image of a computer? It's not just a copy of the files that are sitting there, but it's literally a copy of an entire hard drive. And so, and that's important because one issue is certainly what files are present. The other issue certainly is things in which may be in what's called cache, or things that may be on other parts of the computer that aren't readily available to you, but are readily available to a forensic person. And so that matters, that you properly preserve things. The other piece of that, of course, is properly preserving email and thinking about, if there are issues with email being downloaded or information with email being forwarded to personal accounts or to competitors. Again, you want to think about preserving email. And so having an idea with regard to these things is important. And you also have to think about the areas in which these things can occur. So, for example, people can plug in flash drives, thumb drives, or send things to personal email accounts. So you have to think about, well, what's going on now? People are working remotely. All these things can be going on. And so you have to think about, well, how do I potentially, if an issue arises, how do I preserve devices? How do I secure those devices? How do I inspect those devices? So those are important considerations. The other thing is certainly you need to think about it, as we talked about, is personal devices being used. And why does that matter? Because if you don't own a device that person's using, it is more difficult to preserve that. It is more difficult to get access to that. You don't know if someone's taking pictures of important or confidential information on their cell phone, and are they taking that information, taking a picture of a screen, putting it on their cell phone, and using it for an improper purpose? Or even more importantly, are they taking pictures of things, putting it on their cell phone, and then forgetting it's there, which means you now have information sitting on an unsecured device, a device not owned by the company, and that can present problems because it's not secured. You also have to think about, especially now with people sitting around at home in front of computers, social networking and social sites, because information can be shared that way, whether directly or inadvertently. And so, you need to think about, are people using social media at the same time that they're on their home computer or on a work home computer, and are they putting information into social media about your company, about things they're working on, or information, or inadvertently, they put something into social media. So you need to be aware of that, and then also you need to also understand that, again, was mentioned by Jesse and by Justin earlier, that there may be extra levels of security needed, or there may be what we said is reasonable issues of security that you need to take additional steps because of the unique environment of people working from home and working on different devices. One thing I'll do right now, just so we don't forget, is to read you the code for the CLE credit that you'll need. And the code is as follows: S as in Seyfarth, S as in Seyfarth, 6687. Again, that's SS6687, and you'll need to put that code in your application for CLE credit. Moving on in our presentation here, it's important to have your folks understand the information and who owns information, and to have understand that information, there are many different ways you need to deal with it. So one thing is designation of ownership. And by that we mean in your policies, in your procedures, or in emails or that you may send out, a memorandum or other things, you need to say, we own this information. So why does that matter? That matters because you don't want people to take either the sort of the natural view, oh, I worked on something that's mine, or you get issues of work for hire issues, which is a completely different subject. But it's important to make sure people understand who owns information. People need to understand that data that the business owns is for the business to use. That's information that can't be held up or held by the employee. That you need to understand that data, when the company owns it, it may be information that has to be shared with customers. It may be information that gets moved because there's going to be some transition in the business. Maybe there are vendors that use the information. So understanding the ownership and understanding how you protect that information with agreements with vendors and with agreements with employees and policies and procedures can be extremely important when it comes to who owns information. So we should also talk about sort of the three pillars of trade secret protection. And when you look at trade secret protection, we use this diagram to try to highlight the issues here. So you have the legal aspects, which is contracts, agreements that you enter into with employees and vendors, and you have litigation to enforce these things when things go awry. But also you have the business has to understand there's training that need to be given to employees, training so that people understand what is confidential and how to keep things confidential. And also you need to obviously use physical barriers, access control, security systems, software, secure facilities, have clean desk policies. Tell people, and we'll talk about in a minute some very practical steps, but tell people to put information away when they're done using it. So for example, people are at home and they're using information and they may have it up on a screen, they may have it sitting on a desk. I suspect there's a lot less social gatherings now with what's going on in shelter-in-place orders, but you can't leave information sitting out on a desk at home or sitting up on a screen at home, just as you can't do it in a public place or even at the office. So keeping clean desk policy, clearing a desk, making sure things aren't just displayed on screen. So those are very practical steps that need to be used in order to secure information. Next, we can talk about sort of the current scenarios we have, and we alluded to this slightly, but virtualized environments. People using Citrix, for example, to dial into work. That's an encrypted, secure connection. Maybe people are using laptops that connect to a corporate VPN. Again, those are typically encrypted, secure connections. But then, what we might have is a lot of people working from home on home computers, and that presents a whole host of issues that you need to consider. Why is that? Because home computers aren't necessarily encrypted. They aren't necessarily password protected. They are potentially accessible by numerous people in the house, maybe accessible by guests in the house. And so you have to think about how am I instructing my employees on how to deal with those situations, and hence a good policy or a good procedure to address this is important. And it's that third area that can be most problematic, and that's why we talk about several issues that can come up. Data existing on personal devices, so it might exist on a smartphone, might exist on a thumb drive, it might exist on an iPad, it might exist on a computer, and they might not be owned, or a laptop, which might not be owned by the company. And so, data on personal devices, company data, super important right now more than ever to have a policy in place or instruct employees with a memorandum, instruct employees with a policy. And as was mentioned earlier, literally right now, you can send out a memorandum, an email to your employees reminding them of confidentiality obligations, taking some of the things we've mentioned here and saying to them, listen, company data is owned by the company. Company information, whether it's on a company-owned computer or on a personal device, is still owned by the company. If it's sitting on a smartphone, it's still owned by the company. You need to take steps to protect it. And so, as we talked about earlier, taking reasonable measures and reminding people that if you got into a litigation situation, you can point to that memo that you sent out, that email that you sent to employees. Send it today, send it Monday, but come up with something that you send to employees to remind them of their obligations and to take account of these different situations with personal devices. Or maybe someone has a backup think about this. Someone has a backup in their home. They back up their computer to a time capsule or one of these websites, one of these web-based, cloud-based services where you can back up your home computers. Well, if they're working on company data on that home computer and it's being backed up to the cloud somewhere, not a cloud owned by your company, but a cloud that they use personally to back up their home devices, your information may be sitting there now because someone's using a personal device, a personal computer owned by them, and they're doing work, company work on that device. You also need to think about encryption and transmission of data, information being transmitted from a home computer, and not necessarily over Citrix or other or VPN, other types of encrypted connections. That information is susceptible to being intercepted. It's susceptible to being hacked. So you need to think about what do you want to say to your employees about how information is transmitted. Also think about information that goes into text. Someone takes a picture of something and puts it in a text, or they put it in an email. Same issue. What happens if people are putting things in a personal email and not putting into company email, which company email potentially is encrypted, or it's on secure servers, or done in a VPN connection. Again, you need to think about these things and remind your people about what to do. And of course, you have issues with malware that can always come in when you start working in environments outside of companies. Companies take a lot more steps to protect against malware using all kinds of software and encryption and secure connections or tunnels, but you don't necessarily have that same protection when someone's using personal devices. Similarly, where is information? Where does it go? You need to be aware of that when other devices are being used outside the companies. So here's some very practical things that you can do now and to think about as people are working at home. Obviously, number one, determine if you have a policy, and if you have a policy and a procedure in place for working from home, working remotely, working on utilizing home computers, et cetera, great. If not, create one now. It can't hurt. Do it now. If you need help, talk to your attorney, talk to one of us. Happy to help you with these things. But create a policy now that addresses the current remote workforce. Take an audit. Use SurveyMonkey or one of those types of tools to take an audit or a survey of your employees. What are they doing now? Are they working on personal devices? Are they working? Obviously, they're probably working from home, but come up with a short survey that you ask your employees, what are they doing and how are they doing that? Because it'll alert you to some of the ways they're communicating and working, and that could be super helpful for protecting information. Ask folks where they're working. Are they working from home? Are they working in an office at home? Are they working, which would not be typical right now, depending on what state you're in, but are they working from some public setting? Are they working at Starbucks or some other coffee house? A lot of those are closed right now, but in any event, where are they working? Because that also helps you to figure these things out. And what devices or tools are they using? Laptops, iPads, et cetera. If you can, deploy company-owned devices and memory tools, a company-owned thumb drive, a company-owned computer. Easier to track those things, and there may be software and other things you can employ utilizing those that you can track information and protect them. Another very practical piece of information, sign-in screens, critical. Change your sign-in screen now. When people go into your network, change your sign-in screen if there's something in it that doesn't protect your information properly because it's being used remotely or being used on a personal device. Look at that sign-in screen because people have to click through that each time. Super important. As we said, issue reminders. Conduct a training or webinar call with your folks. If people are sitting at home and they're working at home, very easy time to get their attention when they're, when everyone's at home and has less outside things going on, to conduct a training or a conference call. And obviously enforce your policies, super important. And then you need to be vigilant, monitor for issues, track access to company data and files. Think about what software is being used to protect against malware and spying and viruses. Then also, we don't know when the end of all this is in sight, but at some point there's going to be an end to the sheltering in place. There's going to be an end to the prevalence of the coronavirus. And then what do? You need to make a plan now as to how you're going to return to normal work. You need to develop a plan to ensure that company information is returned. And so you need to figure out now, am I going to go to employees and ask them to upload information off their home computer onto a company server or device? Are we going to provide thumb drives to people to put information on to return to work or to put into the company's document management system or a company cloud? You need to figure out how there's going to be a transition back to the office from the remote workforce that we currently have, because it'll end and people start coming back into the office. Now, how do I account for information on personal devices? What do I need to do to ensure that that information comes back right now? And so that's what you need to think about. You also have to think about what's happened with employees who are furloughed or laid off. Great protection is if someone's laid off, they have a device, take a copy of that device, a forensic image. You take a copy of it and store that copy, because if an issue comes up later, make sure that you have that copy and it can be looked at to look at whether someone copied things or took things out. And very inexpensive to take an image of a hard drive and hang on to it for a period of time. Turn off access to email, turn off access to company data. Exit interview. Conduct an exit interview with people that are leaving. Now there may be a bunch of people laid off or furloughed. It may be impractical, but exit interviews are important. Have people sign certification. If you don't have one, get one made. You need to talk to a lawyer. Talk to your lawyer. A certification that says things like, I'm going to comply with confidentiality policies. I've returned everything. Those sorts of things. Everyone leaving or furloughed or laid off should get a reminder letter that reminds them of their obligations, reminds them of any handbook or policies, reminds them of any contracts that they sign. And again, monitor for issues. At the end of the day, there are other steps you can take to secure trade secrets and cyber threats, everything from using software and equipment, using multi-factor authentication for logins, only allowing access to VPNs and tunnel or secure networks, prohibiting working from coffee houses and public places, prohibiting use of public Wi-Fi versus private Wi-Fi in someone's home, or Wi-Fi on broadband devices provided by the business, possibly impose credentialing, additional credentialing for highly confidential information. These are all steps that you can take to protect data and that need to be thought about as we're in this remote working environment right now. So again, set clear expectations with employees, use training on policies and procedures, conference calls, reminder memorandums, monitor employees, have them check in as to what they're doing, what's going on. Take steps now to enforce, your security procedures, to look at your infrastructure, and require employees working from home to use proper procedures. So a couple resources here. First of all, tradesecretslaw.com. It is literally our award-winning website where you can get a lot of information about protecting confidential information, trade secrets, non-competes, computer fraud issues. Also, we have available our 50-state desktop survey reference that has been repeatedly used throughout the country by in-house counsel and others. It's a nice desktop survey about states, the law in each state. And the Seyfarth team, everyone certainly on this call today, is part of a top-tier Legal 500 recognized trade secrets group, literally in amongst the top 5 or 6 groups in the country identified by Legal 500. So we have a wealth of experience and expertise that we can bring you both on our website, our reference tools, in person, by telephone, email, etc. And we're happy to provide that. And again, you can look at, for COVID-19 issues, you can look at Seyfarth.com/COVID-19. There's a wealth of information on all kinds of different topics, from business law to immigration to employee issues to labor issues, etc. We'll turn this back over to Jesse or Justin to answer some questions that have come in. I don't know, Jesse or Justin, whichever one of you want to address some of these.
This is Jesse here. I'll take a stab at one of them, and this is an interesting question that's been coming up recently that I've seen, and the question was whether or not an Echo Dot or a Google Home or some other smart spot with a microphone on it is a potential security risk. And again, this is something that you'd probably have an issue with regardless of the coronavirus health crisis, but that is becoming particularly acute when you have people working from home in environments where they may not already or may not have previously set up a working environment. And there is no hard and fast rule on this, although we've seen cases on this, and interestingly, they've come up in the criminal context. Many of you may have seen the cases that came up where Alexa just happened to have recorded a certain crime that had been going on because somebody had said certain words. But the long and the short of it to the question is, yes, they do represent a potential security risk. And I would advise, and the advice we're seeing is that I would be wary of them in any environment where you tend to conduct business. I would not have an echo in a home office, for example, or any place where it could pick up your voice. I'm not saying that our good friends at Amazon or Google or Microsoft are deliberately going out of their way to record, but I do know I've had many conversations where I've said the wrong thing and I hear it pipe up on the other end of the room just in other circumstances. So this isn't just my personal opinion on this. We're seeing this as legal advice, and we're seeing this pop up in literature and publications. So I would be very wary of having those devices. Now, how far do you take that? Obviously, your cell phone, your other smart devices are also listening in. And if I were to say certain words right now, perhaps my phone would wake up. But I would say that these devices have a particularly heightened sense of security risk. So I'd be wary of them, and I would look to turn off those things on your phone as well if you are in the business of protecting trade secret information.
Here's another question: difference between a trade secret and confidential information. There is a legal difference between the two. A trade secret certainly is confidential, but it is above confidential information in the sense that the definition of trade secret requires that you derive economic benefit from the information not being known and hard to be duplicated, essentially, and that you take reasonable efforts to protect that information. And so there's a legal difference between the two. However, under many states' law, the two kind of converge, to be honest. There are states where there's case law that converge the two and almost require a heightened standard for something to be confidential. So, many places there is a fine line. Many places there's a gray area because they do converge. Another question here with regard to sample policies. Do we have sample policies? I mean, obviously we've prepared a lot of policies. We've prepared many policies for all kinds of clients, from large and small and all different kinds of industries. But we don't really have samples per se, only because these agreements are all different. These agreements require some tailoring based upon the type of business and the information, the information that's relevant to the business. So, we don't have samples, but certainly we have many that we use and we look at. Someone asked to repeat the code again, so let's repeat that for a moment. SS6687. That's SS6687. Let's see. Another question here. Information. I think we addressed this.
Follow up with us if you have any questions. Our emails and contact information at the beginning of the slides. These will be passed out. We're happy to consult with you further if you have specific questions or would like some guidance.
Yeah, and one last question. Information on smartphone devices. Everything we've said applies to smartphones as well as iPads, computers, laptops, tablets, etc. There's no real difference in how we try to protect these things and what should be protected. But portable devices are a bigger risk because there are many ways to to get into phones, and there are certain threats, both electronic or technology threats, as well as real threats as to how information is used when it's on a portable device. So certainly everything we've said is applicable to portable devices and smartphones, as well as computers, laptops, iPads, etc. I see that we're at the end of our hour here. Anything else, Justin, Jesse?
Thank you all for taking some time out of your day to join us. Obviously, there will be slides that will be distributed, and if anyone you know is interested, this should be available on our website to review at a later time as well.
Thank you. This concludes today's webinar. Thank you, everyone, for attending.